Hi guys, it's Kathy. I hope you're doing well. I'm excited for OJ. Been 2 days. We don't know. Rosa Lopez. We don't know what's going on. We don't know how the prosecution's going to get screwed over today. Maybe I'm just being harsh. No, I'm not. No, I'm not. You all saw what I saw.
As a precaution. 25 names are being withdrawn today. 15 of the 25 names being withdrawn today, rather 16 of the 25 names being withdrawn today are names that were not otherwise on the prosecution's witness list. Therefore, Your Honor, that leaves 108 names that are on our list but are not on the people's list. Your Honor, so the court should understand by way of background, our office first appeared in this case on July 22nd of 1994, one day before the Marianne Gertrude statement was taken, 1 week before the first Rosa Lopez interview. At that time, Your Honor, I can speak for myself, Mr. Cochran, Ms. Chapman, we were focusing as much, if not more, on obtaining and synthesizing the 3 full-size notebooks that made up the homicide book in this case, as well as reviewing the transcript from the preliminary hearing and the grand jury investigation that was ended prematurely. As well, Your Honor, the case at that point was moving at a breakneck speed. We early on had meetings in Mr. Shapiro's offices, and it was made quite plain that Mr. Simpson wanted to fully exercise his rights to a speedy trial, and that under no circumstances would there be any continuances of the trial date. And in fact, I'm sure that the record will bear that that's exactly what occurred. That factor, I believe, is central to a fair understanding of the full circumstances under which both offices were forced to work, and such that there is a reasonable and logical explanation, given the fact that there have been 30,000 pages the people have represented of discovery that has been turned over, that in fact it is invariable and expected that there would be an occasional falling through the cracks. In the beginning, Your Honor, documents that would be...
No, sir. That is not the law. The law doesn't say you have to turn over discovery unless there's a lot, and then you can just skip some because there's a lot.
Generated from either Mr. Pavlik or Mr. McKenna or Mr. McNally were sent directly to Mr. Shapiro's office, and then they were forwarded by fax, usually, to our offices. Sometime in August, that process changed after a conversation that I had with Mr. Pavlik, asking that Mr. Cochran's name be added to the addressee of his memoranda, and asking that Mr. Pavlik directly fax to our office any documents or memoranda that he would fax to Mr. Shapiro's office, because I was concerned that just with all the paper flow, with the fact that Mr. Shapiro's office was being inundated as it was with different discovery, with photocopying those documents and making sure that reports were disseminated not only to counsel, but also to different experts around the country, that we perhaps were not receiving all of the documents in a full and timely fashion. And as a prophylactic device, I then set forth the procedure that Mr. Cochran's name be added.
I approve of
and you will see in the later report that his name was added as a companion to Mr. Shapiro's name, and that the document be faxed directly to our offices rather than having the middle step. September 1, Your Honor, was the date by which the court ordered that we on the defense compile documents and names of witnesses that we would then be including on a list to submit both to the court and to counsel. Because Mr. Shapiro's office was earlier involved in this case and had a better familiarity with the state of the record and the names of the witnesses, their offices took the primary responsibility of compiling the witness list and preparing the documents that were going to be placed in the folder that was then ultimately turned over to the prosecution. I will say that I have always been a part of our office's representation on the discovery effort. I was present at meetings early on, if not in July, then in August, with Mr. Hodgman, meeting on the 18th floor, discussing some of the discovery issues, but I was not present at the meeting in September or in August when the documents that were transferred over were compiled or analyzed. Sometime in early January, Your Honor, when the primary focus of the defense efforts were transferred from Mr. Shapiro's offices to Mr. Cochran's offices, I then assumed responsibility for coordinating that effort. The problem that has occurred, Your Honor, as I've said, is partly attributable to the sheer volume and size of the files and the work that had to be done. Indeed, coordinating an effort of this size between offices that are miles apart takes some coordination, and it is probably not unexpected that there would be occasional lapses in the process. I think also, Your Honor, that the fact that the trial proceeded without a speedy trial waiver, such that the jury selection began 2 months and 3 days after Mr. Simpson's first appearance in Superior Court, is very telling and very important to fairly analyze and consider what really occurred. In January, Your Honor, the 23rd of January, when I was in charge of coordinating the efforts, we were directed to both review our files, and we were also directed, Your Honor, to compile a book setting forth the names of witnesses, setting forth the documents that were turned over, etc. On that occasion, Your Honor, I spoke to both William Pavlik and Patrick McKenna, who were then the two investigators that were presently working on the case, telling them of the problem, telling what my obligations were, and asking whether or not there was anything that they might have in terms of witness statements or other items that would have been complying with the court's directions. My office then, Your Honor, endeavored to...
Are they important? Do we have any idea who they are? Are they lawyers?
To both review the documents.
Counsel, I'm sorry to interrupt. Could we have the investigators for the defense excluded, please?
Yes, gentlemen, will you wait outside, please? Mr. Douglas.
My office, Your Honor, then endeavored to
Not
review
lawyers,
the names that were contained in the documents that were submitted against the names and the documents that were then in our possession, to see if there was any change or any other documentation that may or may not have been turned over. What occurred basically, Your Honor, is that there would be a check-off system such that the name Rosa Lopez statement from Pavlik to Shapiro, 2 pages, was checked off. There's a check mark, and we then went on to the next name because there were dozens of names that we were seeking to review. We had but 2 days to review them and to submit them to the court. I primarily focused on creating the notebook and checking through the names on the notebook and making sure that that was going to be prepared in an orderly fashion, because that was going to be submitted to the court and was also going to be submitted to the other side. What I did not do, Your Honor, on that occasion was to personally check each name of each statement and each date of each witness statement against that which was submitted to the prosecution. I have, however, in the interim, performed that particular task. As well, Your Honor, in January, I did not contact any investigators who had previously been employed by the defense team, but were not then working on behalf of the defense team, because I was under the impression that all of their notes, all of their reports, all of their documents, anything that they had on the case had been turned over to either Mr. Pavlik, who was the senior investigator, by the time of January, certainly 1995. The court should understand that there have been 7 different investigators who have worked in some fashion or context since the institution of this case. That number since late October.
No. Nope. No. So that's not how it works. So what he's saying is, because the prosecution had 7 different investigators, there's no way he could turn discovery over to 7 different investigators. That's not what he did. That's not what happens. He turns discovery over to the prosecution. Who cares how many investigators there were? He doesn't turn discovery over to each individual investigator all over again when a new one comes on. So it doesn't even make sense what he's saying.
October of last year has been whittled down to 2. And my communications and my contacts on virtually a daily basis has been with either or Mr. Pavlik and or Mr. McKenna. Since January of 1993, Your Honor, and up until maybe 1:30 this afternoon, I sat forward in my office and reviewed by date each of the documents, each of the names to determine whether or not, one, there were some names that were simply surplusage and could fairly be deleted. I've compiled a list to that effect. I have not yet compiled a list of those names, the 97 names of Chicago witnesses, because there was simply just not enough time, and I will in the future endeavor to pare down that list as well, working with Mr. McKenna.
Not enough time. Dude, you're in the middle of trial. This is done before trial begins. You are in the middle of trial.
Who is involved with interviewing those particular witnesses?
Not that I know of. Barely enough.
Let's turn to the question of notes and what's happened to the notes. And certainly the court understands that when the court considers the fairness of imposing a discovery sanction, that must be considered in view of the hands and the cleanliness, if you will, of the hands on the other side. I think it is not an understatement to say that 95% of all of the documents that we have received in this case are typed statements by investigators, with the exception of clues, because clues are handwritten. But 95% of all of the other reports are typed statements of the author of a particular document, and there is only a very small percentage that might include a parallel handwritten document of the same statement that is ultimately typed up. We do not have, Your Honor, a wealth of extemporaneous rough notes that may have been taken in the field or that may reflect some extemporaneous markings and thoughts and impressions of Detective Lang, Van Adder, etc. We do have handwritten.
Douglas, let me save us all some time. I'm not really concerned about that.
Well, I want to, Your Honor, there's a question of where are the notes, and I want to just say that so the court understands as I lead into.
I understand the point.
Very well, then I'll move
I
on.
don't find it persuasive.
Very well.
Given the situation we're in.
The notes, Your Honor, as the court will appreciate, were a matter of severe concern for security reasons. It has been clear very early on this case the depths to which others may sink to try to learn intimate facts and details concerning this particular case. I'm sure the court even has firsthand information of how low others will sink to go through trash cans and other matters seeking to find out things about this case. The court will also remember that early in this case, there was a minor incident at Mr. Shapiro's office where there was a sort of a break-in or a tampering of some of the files. That event served to send shockwaves throughout the defense team and necessitated that we take very careful and calculated steps to protect the integrity of the defense effort. That is simply one explanation offered to support the reasons why once documents were prepared and notes were immediately destroyed, because we did not want to have loose notes laying around for anyone to pick up or for them to be misplaced. Let's turn to the question of tape recordings, Your Honor.
That's
Your Honor,
not
I
a legal
represent
argument.
as an officer of the
It's
court that never have I been involved in a meeting or a conversation with another lawyer or another investigator when there was ever any intimation that any particular interview or conversation or defense effort had been tape recorded until Monday evening, when we returned from court to our offices and had a conversation, attempting then to learn everything that was known about any tape recordings. And I will represent that each of the lawyers that I've spoken to, and I've spoken to all of the local lawyers on the team, there is not one lawyer that had any knowledge, notice, or understanding that there had ever been a tape recording of any particular witness until moments before it was announced here in open court for all to see. Other than the statements of Mr. Kaland and Alan Park that Mr. Shapiro turned over at the preliminary hearing early in the case and before our office was involved in the case. That was the reason, Your Honor, that I could state and Mr. Cochran could state with seeming confidence that there were no other tape recordings in existence because we knew that there was no other. It would be sheer folly, Your Honor, for anyone to suggest or believe that I would stand before this court or any other court and boldly state that no tapes exist if I had known the true facts to be different. I take my obligations as an officer of this court very seriously, and I would not knowingly mislead this court as to something as serious as that. I would also like to share, Your Honor, that I take my obligations under the Discovery Act and under Prop 115 equally as seriously. I appreciate the reason for the concern. I appreciate the necessity for this inquiry, but I strongly feel that any problems that were then in existence have been resolved. I am of the opinion that there will not be any future problems. There is, as I've mentioned to the court, my need to clarify in my own mind a couple of matters with you consistent with the rules of this court so that we may in chambers ex parte decide whether or not there would be an obligation for us to turn over, for example, certain documents that we have in our possession that are impeaching or used to perhaps impeach a witness that is on the prosecution's witness list. And Your Honor, just to lend some insight into the interpretation of our obligation in the Discovery Act, I think it important to note that though we have no obligation, and I think it plain, to turn over any reports of any statements of witnesses who are presently on the prosecution's witness list, we did in our September 1 filing turn over a couple of such statements, particularly, for example, in connection with Dale St. John. He is a prosecutor.
So what he's saying here is he's taking a whole bunch of things and he's like spaghettiing them together. And he's saying, we need clarification on this rule. No, you don't. The rule was given to you a while ago. If you needed clarification, that's when you should have asked for clarification. You can't come around now and ask for clarification now that you didn't comport with the rule. And then he's saying, we did give this information to them. Okay, besides the point. That doesn't mean you did give the other information too. It's besides the point, and you're mixing them together, and neither of them are legally okay.
Prosecution witness, we turned over statements that we had concerning Mr. St. John. Pat Berman is a prosecution witness. We turned over statements that we had on Ms. Berman. That simply is offered to prove that it is not and has never been our intention to engage in gamesmanship or to boldly flout any of the directions or orders of this court or any of our obligations in complying with reciprocal discovery. In closing, Your Honor, as I've said, the cause for the court's concern is justified. I do believe, however, that there are no other documents that exist that we are obligated to turn over. I have, Your Honor, endeavored to obtain, and I am still obtaining, sworn declarations from each of the other investigators who have worked on this case, acknowledging what they have all told me personally. And over the last 2 days, I have spoken to all 7 of them personally, 2 of whom I had not spoken to until Tuesday afternoon, but each of whom have told me that there are no records in their possession, there are no handwritten notes in their possession, there are no tape recordings in their possession, and I represent that to the court. I would like to add, Your Honor, that my recollection of Mr. Pavlik's remarks, and Mr. Ullman can comment on them more fully, was that the fact that he was alone was only one of the criteria which led to his choosing to tape record the statement of Rosa Lopez. It was not the sole criteria. He said that she was a female. He said that she was Spanish speaking. All of these reasons, I think it also important that she was an important witness. All of these factors, and I think probably the more important factor was the potential language problem and the difficulty in making sure that one could clearly record and recall that which was said would be the primary reason why he chose to tape record that particular interview. I have, Your Honor, had more than a dozen conversations with Mr. Pavlik in the last 2 days since this disclosure, repeatedly asking him whether or not there are any other statements, why he chose to tape record that particular statement. Are there tape recordings of any others? And he's assured me that there are no other tape recordings, that he did not record any of the witnesses, and there's nothing else in his possession. Dean Oman, Your Honor, I'd like to complete the remainder of our offer.
Well, Mr. Douglas, before you leave, let me ask you this question. What is your response to the prosecution's request that I instruct the jury that the delay that we've experienced since Monday is a result of a failure of the defense to turn over this tape recorded statement regarding Rosa Lopez, that I lift the sanctions delaying the presentation of some of the prosecution's case, that I admonish the jury at the time Ms. Lopez, even when the 1335 is played for the jury, that I admonish the jury as to the delay in the failure of the defense to adequately comply with the court's previous orders, and that I allow the prosecution to argue during the course of the closing argument the withholding of evidence by the defense. Also, what is your response to their request that I require you to submit to the court within a
Judge, come on. We did do all that, but it's not fair if you tell the jury we did it. Come on, Judge. It's not fair.
timely manner a list of the names of all the witnesses on your witness list as it exists today, the dates of each interview, the dates of each written report, whether or not there are any notes in existence, whether or not there are any video or audio tapes or any other memorialization existing with regards to those interviews.
As to the witnesses, Your Honor, that are currently on our witness list, I already compiled the table, if the court will recall, that provides that particular information. There is whether or not the witness was on the prosecution's list, whether or not the witness was interviewed and the date, whether or not a statement was taken and the date to which each was turned over. We had prepared, Your Honor, for Dean Ullman to answer the specific questions concerning this discovery sanctions, and I would defer to him if the court pleases.
All right. Madam Reporter, how are you doing?
Today, Your Honor, seems a particularly appropriate day for the defense to appear in sackcloth and ashes. And we do. We appear before the court as penitents. We screwed up. We admit that. We apologize for that. I know I speak for every member of the defense team in offering a sincere apology to the court and to counsel for the prosecution. The only explanation we can make is that we are human, but we do not admit to ignorance of the law or contempt for this court's orders with respect to any of our efforts with respect to complying with the discovery law. I think we have made an effort in every case where there was some confusion in terms of how this law should be applied to get a ruling from the court and to comply with that ruling in good faith. We are not contending everything is privileged. The privilege argument that was presented to the court today is based squarely on a ruling of the Court of Appeals in the Rodriguez case. Justice Ardias, who is certainly not a Pavlovian defense advocate, recognizing that there are serious privilege problems in the context of making discovery of expert reports. I think Your Honor, of course, realizes that the biggest motivator for lawyers to comply.
No, Carla, we are not okay. Not okay. These guys are making us lose our freaking minds right now. And it's not okay. I don't understand how the entire nation watched this happen and it was allowed to happen. I don't understand how, other lawyers or somebody didn't say, wait a second, you're not allowed to do that. Judge, I'm just solely on the judge because the defense team are criminals. Everybody knows that. It's not like that's a shocker. But the judge should not have allowed it. The judge should have done something about it. So no, we're not okay. We're mad and we're not going to take it anymore. Oh, wait, that was a different one.
With what the law
Happy Easter.
requires in terms of discovery is not the threat of sanctions. It's the fear of losing their credibility, of damaging their reputations. And those are motivators that apply equally to all of the lawyers involved in this case. And I don't think there is any basis in the record that we have before us to assume that any of the conduct that Your Honor is dealing with involved deliberate concealment of evidence. We would not be here discussing sanctions because we are dealing here with evidence that was disclosed, although later than it should have been. And we certainly admit that. I think it's also ironic, Your Honor, that we're discussing this issue only 3 weeks after we were screaming just as loudly as the prosecution in this case over the delay in producing a videotape of Mr. Simpson greeting guests the evening that this murder took place at the junior high school or the junior school where the presentation by his children had taken place. And it was interesting because that
Irrelevant. Has no basis in what happened right now. Absolutely none. They did it so we can do it too, only worse? No. They got sanctioned for that. You should be sanctioned for this. Not too long. I think someone said it in chat the other day that it was like a couple months. Like this all started to happen a couple months after the riots.
tape had been in the hands of the prosecution since June. And it was only made available to the defense approximately 3 weeks ago. And just as they're screaming about this, we were screaming about that. And the explanation that was offered was a very simple one. It fell through the cracks. And I find it ironic that when it turns out we've got some cracks ourselves, that the immediate conclusion is leapt to
Yay,
that there was
you.
some sort of deliberate effort here to conceal evidence or to engage in unprofessional behavior. The question of sanctions is addressed directly by Section 1054.5 of the discovery law. And it indicates upon a showing that a party has not complied with Section 1054.1 or Section 1054.3, which is true, and upon a showing that the moving party complied with the informal discovery procedure provided in this subdivision, a court may make any order necessary to enforce the provisions of the chapter, then specifying a number of alternative sanctions. And the question we would simply address is whether the prosecution is in a position of being able to come before this court, especially in view of what just happened 3 weeks ago, and say that they have fully complied with all of the informal discovery procedures themselves. This is not in any way to denigrate or to indicate that what we did is less serious than it is.
Hi, Jen.
But simply to indicate that there are going to be human errors made on both sides. And I think the purpose of fashioning a sanction is to put things right, to level the playing field, to eliminate
To punish criminals, punish them.
any advantage that a party might have gained by their failure to fully comply with the discovery law. And that, I think, was the guiding principle in Your Honor's imposition of sanctions against the prosecution, of imposing the sanctions simply of, since all of the witnesses who were revealed later than they should have been delayed the defense efforts to conduct investigations, those witnesses could not be called until.
I'm sorry, it delayed it, but they got 6 weeks. They were allowed 6 weeks as a sanction. And he's saying that those witnesses, had to be called later because of this. The trial didn't even start yet, or barely started, and they got plenty of time to fix it.
Till all of the previous witnesses had been called. So it was essentially fashioned to put the prosecution in a position they would have been in if they had fully complied. And I think we need to seek the same sort of equity in this situation, to put right any wrong that they have had to endure in terms of their position as litigants in this case. But sanctions should not ever redound to the detriment of the defendant himself, to burden the defendant who is on trial with the sins of his lawyers, and to suggest to the jury that the defendant or the evidence that he is presenting is less credible because his lawyers did not comply with a specific statutory requirement. And I think it would be highly inappropriate under these circumstances to suggest to the jury that any adverse inferences could be drawn against Mr. Simpson based on the withholding of evidence. I invite Your Honor to look at the CalJIC instruction on the concealment or withholding of evidence, and it makes it quite clear that that instruction is only appropriate when the concealment or withholding of evidence is directly attributable to the conduct of the defendant himself, not the conduct of his lawyers. With respect to lifting the sanctions that have already been imposed on the people, those sanctions were imposed to even the playing field. And it's not going to even the playing field in terms of the disadvantage that the defense suffered by the late disclosure of prosecution witnesses to lift those sanctions when we're dealing here with the late production of one tape recording with respect to one witness on the part of the defense. I think Your Honor has largely already addressed the problem created by this tape recording itself in requiring immediate disclosure, in delaying the testimony and allowing the prosecution time to analyze that tape recording and prepare to cross-examine the witness, and by imposing on the defense the costs of the delay to the extent that it required additional accommodation of the witness. I honestly don't believe that any further sanctions are necessary to right the wrong and to level the playing field in this case. I think what Your Honor does have to be concerned with is to make sure that this doesn't happen again. And I think the suggestion of requiring the defense to provide the very detailed accounting that Mr. Douglas has already offered to the court, laying out precisely every witness on our list, when and where they were interviewed, when the statements were turned over, and to require that be submitted under oath should remedy the problem.
Thank you, counsel. Well, we're beyond the one attorney rule.
If I may indulge the court just for a brief moment.
Briefly.
No,
Thank
you may
very much, Your
not.
Honor.
Object.
The court is, I'm sorry, but the court has been very,
Uh-huh.
this is the one thing the court has held to, and requiring one lawyer per issue.
And they yelled at Marcia and they yelled at Darden and they wouldn't let them talk.
I argued the earlier
Well,
motion. Ms. Clark is arguing this one.
The reason I am going to indulge Mr. Shapiro is because Mr. Shapiro's conduct as being the conduit for all of these reports calls into question his professional reputation. And I think he's entitled to address that issue. I assume that's what you're
Oh,
going
Yes, Your Honor.
You're
Thank you.
right. Okay,
I
I'm
would-
sorry. I'm so sorry. Yes. If the lawyer's reputation is at stake, screw the law. The law doesn't matter.
The same for any counsel.
Thank you, and I appreciate the opportunity. Your Honor knows the speed at which this case has moved and knows the number of lawyers on both sides that have been involved. I was hired as Mr. Simpson's initial lawyer and remained his lead counsel until the beginning of presentation of evidence, at which time Mr. Cochran took responsibility as being the chief trial lawyer for this case. But this began and this remained as a team effort. And as such, somebody on a team must take ultimate responsibility. Since I was in charge of this team, from the time that Mr. Simpson returned on the 13th of June until the time of the presentation of evidence, I will take that responsibility. And if there are sanctions to be imposed,
That means nothing, dude. Nothing.
those
Sit down.
sanctions should not go towards Mr. Simpson because of his choice of lawyers, but should go to his lawyers who in fact are responsible for the position the court finds itself in today. As to what is an appropriate sanction, I will say the following to Your Honor, that my policy has always been an open discovery policy. And I shared that policy with Mr. Hodgman up until the time of his recent unfortunate health problems, where I offered him the opportunity to come to my office and review everything we had. I will tell Your Honor,
No, I object to that argument at this time, Your Honor. Mr. Hodgman not being present to tell us what was said.
Mr. Hodgman won't contradict that. I will also tell Your Honor that
Oh, come on,
the
Judge.
only tape recordings that I was aware of until yesterday in this case were the two tape recordings that I did myself, which was unique for me, but because of the time limitations placed upon us and the desire to get information fresh and to never be in a position where anything that I might have said to a witness could ever be misinterpreted, I recorded those conversations between Mr. Kalin, Mr. Park, and myself. And I immediately turned those over to Mr. Hodgman, although I had no legal, moral, statutory, or other.
First off, you're a liar. It didn't slow you down. It didn't, because you were in such a big hurry, you didn't have time to do that. That's just a lie. The judge gave you extra time. Second off, irrelevant. What you turned over to them is irrelevant. It doesn't matter.
Reason to turn them over, I felt that it was a proper thing to do. We are here now to address two issues that I think Your Honor is rightfully concerned with. Number one, there were two reports of memorandums to myself regarding the interview of Rosa Lopez. It came to my attention during the presentation of testimony that there was an error, that two reports existed, that only one had been turned over. I immediately called the lawyers together and we went into chambers to discuss the issue with Your Honor. The second was when Your Honor asked me to call Mr. Pavlik. I reached Mr. Pavlik immediately. He had been watching the proceedings, and I asked him if there were any notes or tape recordings. He immediately told me he tape recorded the first interview. I said, come to court immediately. That time I met with Mr. Pavlik right before Your Honor called him in and told him he had to disclose that to the court. So in both instances, even though it was negligence on our part, even though
Oh,
those
mine
were
too.
our obligations to find out, we did not. However, as soon as they became apparent to me as an officer of this court, I made it available to Your Honor. If I have been in contempt of court, I will suffer appropriate sanctions. Thank you.
Thank you. All right, Ms. Lewis, do you have any response?
Electric chair.
No, this is, Ms. Parker's been handling this particular motion with regard to witness statements and so forth. I don't see how counsel can stand before this court and argue the fact that they have sometimes complied with the discovery laws to avoid the sanctions that should be imposed upon them for the very egregious misconduct they've engaged in with respect to the most recent and, of course, the opening statement violations that we've seen. For Mr. Ullman to stand before this court and say that no sanctions are needed is offensive. For Mr. Ullman to stand before this court and attempt to avoid the sanctions that are sorely needed in this case by saying he wears sackcloth and ashes should be unavailing and unimpressive to this court. Frankly, I don't care if he wears a dress, because what he wears is of no moment to the people's right to a fair trial. That's what I want to see here. And that's what the defense has been actively engaging in trying to prevent. It is trying to prevent the search for the truth. And what the court should look at is the fact that their fear of losing credibility is obviously not enough of a sanction. How can they even bear to utter those words after they engaged in such serious misconduct during the opening statement, making those representations about witnesses who were never produced, upon whom they relied, placed great reliance, obviously, in mentioning in their opening statement.
Which is why the court imposed an unprecedented sanction.
That's right. That's right, for which we applaud the court in its willingness to take a step that is unprecedented. And in a case like this, that takes a lot of strength. And we do appreciate that, Your Honor. We do. But for counsel to get up and tell this court that no sanctions are needed when now they've engaged in the very same thing and in an egregious manner is really something to behold. To compare a videotape submitted by a private citizen that goes to a barely peripheral issue of little evidentiary value, which was given to them, to what they've done with Rosa Lopez and what they've done with the opening statement witnesses is unconscionable, is just unbelievable. And it's very interesting now to hear the defense attempt to excuse its misconduct due to the speed of the case and to plead their humanity. Those were arguments that they were particularly unmoved by when the people were just 2 or 3 weeks late in discovery with some of their items. And they complained about 30,000 pages of discovery. It wasn't theirs, Your Honor. That was ours. It's understandable if something slips through the cracks when we have 30,000 pages of discovery and hundreds of tapes, audio, and video. It is not understandable when the statements of a key defense witness, and they only have 70 or 80 pages of discovery, but nevertheless, the statements of a key defense witness somehow slips through the cracks. That's unbelievable, and it should not be accepted by this court at face value as being something that was merely negligent. They were afraid when this witness took the stand that she would be asked on cross-examination how many times she spoke to Mr. Pavlik, and that maybe she's not controllable enough, she would come out with that fact. Yes, I've spoken to him 2, 3, 4 times. Who knows how many times now, Your Honor? That's what they're afraid of. And that's why that report came floating out at the 11th hour. I think that the reason that the sanctions requested by the people are so imperative at this time is that what we have here is a continuation of a pattern. It's a sinister scheme, and it's one which was revealed at the time of opening statements and one that has now been continuing. In each case, we aren't talking about peripheral witnesses, Your Honor. We're not talking about a chain of custody witness. You know, you could understand where that might be slip someone's attention. We're talking about key statements, key evidence, and key witnesses. No lawyer, let alone one for the dream team, is going to misplace a statement of a key witness, misplace a tape recording of a key witness. This makes no sense. And although Mr. Douglas claims to have taken his obligation to follow the law very seriously, he certainly has shown his contempt for it, not just by his action, but by his words. If the court will recall, the last time we visited this issue, after the opening statements, Mr. Douglas argued vehemently and with passion his disbelief, his unwillingness to follow the law of discovery, in his belief that it was in derogation of the defendant's rights. And what you're seeing now is conduct consistent with their true belief. They do not believe they were required to follow the law. They have shown their contempt for the law.
And that's exactly what they said. That's exactly what they said. They said they don't believe they have to turn this over.
And they will continue to flaunt the law unless the court makes them pay. It's a cost-benefit analysis, Your Honor. If it doesn't hurt badly enough, then they're going to keep doing it because they have gotten away with so much and they are still ahead of the game, way ahead.
Strategic and tactical win on your part, don't you think?
Depends. At this point, knowing what we know about Rosa Lopez, we want them to call her, so
Well, then maybe you should subpoena her.
maybe we will. In any case, Your Honor, yes, I'm sure that's been a great burden to the defense. 4 millionaires over here paying, what, 100 a night? Anyway, when we visited this issue after opening statements, we saw them argue to the court that everything was taken care of. And now we're hearing the same argument again. No, I can't believe that that anybody buys this anymore. Certainly the people do not. They argue vehemently that a sanction should not redound to the detriment of the defendant. It doesn't. It redounds to the detriment of the witness. Given the fact that under our discovery laws now, the court is well within its authority to preclude the introduction of evidence altogether, to deny them the right to call a witness altogether. It is clear that allowing the people, and the people haven't even asked for preclusion, although we would be well entitled to at this point. All we're asking from the court is the admonition to the jury and the ability to argue what is a clear pattern of conduct by the defense, because this is a sinister scheme. This is a conspiracy. You know, they are trying to hide the ball. They are trying to prevent the jury from hearing what the witnesses are really about and from hearing the truth. And I think that at the very least, the people should be entitled to argue that fact, to say this witness was withheld.
All right,
This
do you
statement
recall-
was.
Do you recall the instruction that I gave to the jury before I allowed you to reopen? That jury can take into consideration the impact or delay on the credibility of a witness, if any.
Mhm.
However, as Mr. Ullman pointed out, the case law that deals with the jury instruction regarding the fabrication and manufacturing of evidence, the hiding of evidence, there must be a direct link to the defendant as authorizing that conduct before I can give that instruction.
No, as I understand it, Your Honor, that's not the same instruction, though. We're
No,
asking
but
for-
certainly it's analogous.
I don't think so.
Delay in disclosure and willful non-disclosure. In any event, something to think about.
Yeah,
All right.
and obviously the court if the court would like, we would draft an admonition for the court's
I think
review.
I've already done something about delay of disclosure of witnesses or information regarding witnesses, haven't I?
You mean in the
Something
opening
pretty close,
statement?
yes. All right, Ms. Clark, do you have any other comment?
Yes, specifically this, Your Honor. Mr. Douglas again indicates a lack of understanding of the law of discovery when he indicated today that any reports that were generated solely for impeachment are not discoverable. That's not correct. That is not the law. Under Izazaga, reports on impeachment are discoverable if they contain witness names or statements that are to be introduced in rebuttal. Only if the defendant goes back and re-interviews a witness the people have provided and gets an inconsistent statement is that not discoverable. So just so we're clear on that. With respect
I
to
think
then,
you're referring to, what is it, footnote 7? And
is it
Izazaga?
footnote 7?
Footnote
And then
14.
14. Yeah, one's a pass,
One of those,
we know,
Yeah.
the dog-eared pages we all have.
14, footnote 14.
I think it's really interesting, too, that counsel now attempts to expand the circumstances under which Mr. Pavlik will tape to include being female. What is it about being female that requires us to be taped? I'd like to know. And I'd like to have Mr. Pavlik under oath and ask him those questions, too. I really want to know about that one. Nevertheless, Mr. Pavlik himself, when questioned, indicated that the criteria he used was that he was alone and without a partner. And that's a nice gender-neutral reason that I think makes sense. However, we have to find out if that's true, because if that's true, there are a number of witnesses that he refers to as having interviewed alone, and we have no tapes for them. And if the court would like, I can read those names into the record.
Please.
Ms. Lynette Goldner, Goldner. Ms. Cassandra Ahern, Ahearn. Mr. Thomas Talarino, Talerino. Mr. Richard Aaron, Aaron. Mark Partridge,
A Ron.
Ronald Taylor, Taylor. Steve Valerie, Valerie. For whom we have one statement on June 23rd and another one on June 17th. Howard Bingham, Bingham. Richard Walsh, Walsh. Tony Valenzuela, Valenzuela.
This is insane. This is
Mr. Ed McCabe, McCabe. Bethy, Bethy, Vaccarano, Vaquerano. Ms. Kay Bell, that's K period. Mr. Jason Wood, Mr. Tony Parker, Ms. Rachel Berman and her mother Pat Berman and her father Mr. Berman,
they forgot a whole family.
and Michelle Abudram, Abudrahm.
They forgot all of these.
All of those were indicated by Mr. Pavlik as having been interviewed by him alone. And we would like for the court to inquire of him under oath as to where the tapes are that should exist of those interviews. 20. Those are 20 witnesses.
All right. Any other comment, Ms. Clark?
Thank you, Your Honor.
All right. All right, thank you, counsel. Due to the lateness of the hour, I'm going to take the motion for sanctions and further discovery orders under submission at this time. I'll issue a written ruling on this matter as well. And Mr. Douglas, you had asked for a 1054.7 in camera. I'm going to continue that over till tomorrow morning at 8:30.
That's fine, Your Honor.
All right, I'm going to order you to be here. I'm sorry. 8:30. All right, I have another sentencing matter at 8:30, but be here at 8:30. All right, counsel, anything else before we stand in recess? All right, Ms. Clark, are you aware of any reason why we can't go forward with the 1335 tomorrow morning?
I haven't heard anything, so I'm assuming we will be ready to go.
All right. Anything else, counsel? All right, tomorrow morning, 9 o'clock. And Mr. Douglas, 8:30. All right, thank you, counsel.
Well, that happened.
Anything we need to put on the record before we invite Ms. Lopez to rejoin us? All right. Deputy McNair, let's have Ms. Lopez, please.
Mr. McNally, Irma, and Mr. Pavlik, if he is here.
Yes, any other persons who may be called to testify regarding this witness be excused from the courtroom. All right, Ms. Lopez, would you please resume the witness stand?
No purple today.
All right, good morning, Ms. Lopez.
Buenos días, señora López.
Buenos días, señor.
You're reminded that you're still under oath.
Se les recuerda que todavía está bajo juramento.
Sí, señor.
All right, let's
Yes,
have
sir.
it quiet in the courtroom, please. And Mr. Cochran. I don't know. Include your direct examination.
Thank you very kindly, Your Honor. And at your request, Your Honor, I'm now wired. Let me make sure that she's picking up my voice. Thank you, Your Honor. This will enable me, I understand, to move around as needed. Thank you very kindly, Your Honor. Good morning, Ms. Lopez.
Buenos días, señora López.
Buenos días, señor.
Good morning, sir.
Are you glad to be here today?
¿Le da gusto estar aquí hoy?
No, señor.
No, sir.
Why not?
¿Por qué no?
Oh,
Prefiero oír que la señora Clark dijo que mi vida estaba más bien aquí.
I would prefer, I heard that Miss Clark said that my life was better here,
Pero quiero decirle algo.
but I want to tell her something.
Prefiero,
Ms. Clark, are you conducting this?
It is irrelevant, Your Honor.
It is. It's non-responsive. However, Ms. Clark, I'd appreciate, this is the third time we've done this on this witness.
just ask another question.
Please.
Yo, did you hear that? They are in front of the jurors. They are in front of the jurors. Were we not all here in the last hearing where the jury was out and Mr. Cochran wanted to speak even though he wasn't allowed? Because it wasn't him that was doing it. It was the other attorney. And they stood up and they said, objection. He can't speak. Only one lawyer. You've yelled at us twice for that. And you're letting him speak. And the judge is like, oh, yeah, I'm going to let him speak. Then the jury comes in. And he yells at her for speaking. What the hell is going on? And he does it in front of the jury.
You still would rather not be here, is that right, ma'am?
De
no,
todas formas, usted preferiría no estar aquí, ¿no es eso así?
sí.
Yes.
And are you still planning to leave the Los Angeles area as soon as you finish testifying?
¿Y todavía planea irse del área de Los Ángeles en cuanto termine de dar testimonio?
Sí, señor.
Yes, sir.
Now, when last we asked you some questions, I guess that was on
Ahora.
Tuesday,
La última vez que le hicimos preguntas, el martes pasado,
you described a detective who came to your door in the early morning hours of June 13th, 1994. Do you recall that?
usted describió,
I mean, she talked about a detective here, that's what I'm saying.
All right, rephrase the question.
Okay. You talked about a detective who came to your door in the early morning hours of June 13th, is that correct?
usted habló acerca de un detective que habló con usted temprano por la mañana del 13 de junio del 94. ¿Es esto correcto?
Sí, señor.
Yes, sir.
And you told us this detective was named Mark Fairman, is that what you said?
Y usted nos dijo que el nombre de ese detective era Mark Fairman. ¿Es eso correcto?
Sí, señor.
Yes, sir.
And if you were to see a video of this particular person, would you be able to identify him?
Y si usted viera un video de esta persona en particular, ¿usted lo podría identificar?
Sí, señor.
Yes, sir.
And I would like to have Mr. Harris call up a portion of a video.
I would object. Show the witness a video of a single individual would be unduly suggestive, Your Honor, and leaving.
She's given us the name, Your Honor, and if she can identify it, then so be it. If she can't, then so be it.
And in addition, if I might,
Hold on.
I'd like to see the exhibits before they're shown to the
He's
witness.
seen this before, and I'll be
What-
glad to.
what have I
All right,
seen?
let's display it on council's video only, please.
Not up on the witness
Right.
video. Council seen an opening statement.
Show the witness a single photograph, Your Honor, is unduly suggestive. In addition, there was a name flashing directly across the individual's chest there.
You can show the first part without the
His
name.
name is in it. And they just all said this right in front of the witness. So, whatever.
The
Whatever.
person is seated at the
Stop it.
witness stand with a microphone, just like this one. It's so suggestive. It's objectionable, Your Honor.
I can ask a couple of other foundational questions. Rick.
Please.
Thank you.
Okay.
After this detective, whom you said was Mark Furman, came to your residence,
Después de que ese detective, quien usted dice que es Mark Fairman,
did you ever have
llegó a su
occasion
casa,
to see that individual in court on television at any time after June 13th, 1994?
Sustained.
Did you ever, Your Honor, if I can ask this question, did you ever see this person on television at any time?
Yes.
¿En algún momento dado vio usted a esta persona en televisión en algún momento dado?
Sí, señor.
Yes,
And
sir.
When was that?
¿Y cuándo fue eso?
Cuando vino él a testificar.
When he came to testify.
And how did you see him when he came to testify?
¿Y cómo lo vio usted cuando él vino a dar testimonio?
Lo mismo como cuando lo vi en la puerta.
The same way, like when I saw him at the door.
And was it the same person?
¿Y era la misma persona?
Sí, señor.
Yes, sir.
And you saw this on television?
¿Y usted vio esto en televisión?
Sí, señor.
Yes, sir.
And do you think you'd recognize this person again if you saw a video of that person?
¿Y usted piensa que reconocería a esta persona de nuevo si usted viera un video de esta persona?
Sí, señor.
Yes, sir.
Sure, and I'd like you to show the video, at least the first part of it.
Have you shown this to her before?
No, I'm not showing you, no.
All right, it's overruled, goes to the wait.
All right. And can you stop it before there's any name comes across the screen? Or at some point, if that, I'd prefer their name not be on there.
Or can we just play it, Mr. Harris, and just freeze it at that point and then put it on the screen?
Freeze that. Can you freeze that?
Baby's breath. Go put some baby's breath or something shiny, like a little strand of diamonds. They sell them, rhinestones. LED
All right,
lights.
Can we freeze
Little
that?
strand of LED lights. Yes,
She has already seen it
wrap
all.
it around.
Now, have you looked at, you haven't looked at your monitor yet, have you?
Ahora, usted todavía no ha visto su monitor, ¿correcto?
No.
No.
Okay. Can you look at your monitor now?
¿Podría ver a su monitor ahora, en este momento?
Sí.
Yes.
All right. Do you recognize the person in that, depicted in that photograph there, ma'am?
¿Reconoce usted a la persona que muestra esa fotografía que está ahí, señora?
Sí.
Yes.
And who is that person?
¿Y quién es esa persona?
Mark Fermer.
Mark Furman.
And is that who is that man in relation to, is that the same man you saw on June 13th, 1994?
Good job,
¿Quién es esa
interpreter.
persona en relación a... ¿Ese es el mismo hombre que usted vio el 13 de junio de 1994?
Sí, señor.
Yes, sir.
And is that the individual we had the conversation with that morning?
¿Y ese es el individuo con quien usted tuvo una conversación esa mañana?
Sí, señor.
Yes, sir.
Is that the same person who promised you and LAPD officers would come back and talk to you?
¿Es la misma persona?
Sustain.
Your Honor, I would like it to mark this as, I'd like to have that printed and mark this as defendant's next in order, if the court please.
Yes. 1046.
Will the court require Mr. Cochran to mark the entire video for purposes of this hearing? The witness did see the entire
Yes.
video.
Well, not the entire video.
Entire video,
Well,
without
she saw
marking.
Mr. Furman's name. and-
All right, Mr. Harris, you'll make that available to us. Thank you.
And I'd like to mark, if it's not going to be marked by Mr. Cochran, I'd like to mark.
I'll
people's next in
mark it,
line.
I have no problem.
1046 is the video, 1046A will be the still from the video.
Can you print out the still?
All right, proceed.
Thank you very kindly, Your Honor. Now, you mentioned at some point, Ms. Lopez, that you knew something about the inside of Mr. Simpson's house. Do you recall that?
Ahora, usted mencionó en cierto momento, señora López, que usted sabía algo acerca del interior de la casa del señor Simpson. ¿Recuerda eso?
Sí, señor.
Yes, sir.
And would you tell the court whether or not you'd ever been inside the Simpson residence at Rockingham?
¿Y le podría decir usted al juez si en algún momento dado ha estado usted dentro de la casa del señor Simpson en la Rockingham?
Sí, señor juez.
Yes, Your Honor.
And what was the occasion that you were, occasions that you went inside that residence?
¿Y en qué ocasión o en qué ocasiones es que estuvo usted dentro de esa casa?
Porque Michelle me invitaba a tomar un té cuando estábamos solas.
Because Michelle would invite me to come over for tea when we were alone.
And who was Michelle?
¿Y quién es Michelle?
Era la housekeeper de Mr. Simpson.
She was Mr. Simpson's housekeeper.
And when you, on the occasions when you go over for tea, was Mr. Simpson ever at home during those times?
Y en las ocasiones cuando usted iba a tomar té, ¿el señor Simpson estaba en casa en esas ocasiones?
No.
No.
All right, did you ever have any other occasion to interact with Michelle or do anything at the Simpson home?
Muy bien, ¿en algún otro momento tuvo usted la oportunidad de juntarse con Michelle o hacer alguna otra cosa en la casa del señor Simpson?
Sí, señor.
Yes, sir.
And tell us about that, if you will.
Y háblenos con respecto a eso, si podría hacerlo.
Michelle un día me llamó por teléfono
Michelle wasn't feeling, one day she called me on the phone
que no se sentía muy bien
that she didn't feel very well,
y quería que le hiciera el favor
and she wanted me to do her the favor
que hiciera la cama de Mr. Simpson.
to make Mr. Simpson's bed.
And do you know when that was?
¿Y sabe usted cuándo fue eso?
No, no me recuerdo.
No, I don't remember.
On how many occasions that happened that you helped her out by making Mr. Simpson's bed?
¿Cuántas veces pasó eso de que usted le ayudó arreglándole la cama del señor Simpson?
Una vez.
One time.
And was he home on that occasion?
¿Y él estaba en casa en esa ocasión?
No.
No.
And that was the only time?
Y esa fue la única vez.
Sí, señor.
Yes, sir.
Now,
Sorry, Amy, I didn't realize it was Facebook. Hi, Amy from Facebook.
on Tuesday, you described for us that after 10 o'clock, you came out with the dog and walked the dog in the front of the house. Do you recall that?
Ahora, el martes usted nos describió que usted había salido con el perro y que había caminado al perro enfrente de la casa. ¿Recuerda usted eso?
Sí, señor.
Yes, sir.
And when you're up in the front of the Salinger's home on Rockingham,
Y cuando usted estuvo enfrente de la casa de la familia Salinger sobre la Rockingham
with the dog,
con el perro,
were you able, from the place you were walking the dog, able to see the Bronco?
usted pudo, desde el lugar donde se estaba caminando al perro, ¿pudo ver el bronco?
Sí, señor.
Yes, sir.
With regard to this dog, is the dog, is that a young dog or an old dog, or what about that dog?
Con respecto a este perro, ¿ese es un perro viejo, un perro joven o qué nos dice de
Eyeliner,
ese perro?
definitely.
No recuerdo porque no Mr. Salinger le pregunté la edad del perro y no me acuerdo. Parece que tiene 39, 34, 39 años, algo así.
I don't remember. I asked Mr. Salinger the age of the dog, and I think he said something like he's 34, 39 years
I don't
old.
know.
I don't remember, something like that.
7 years, something like that. I don't know.
7 years, something like that. I don't know.
I, one of the reasons I asked you that was that you'd said something about the dog bit himself or scratched himself.
Una de las razones por las cuales digo eso es porque usted dice que el perro se mordió, se
If I
rasguñó.
can finish. You'd mentioned
Algo
that
así.
the dog had some kind of a collar because of some propensity to, or some inclination to bite or scratch itself.
Usted mencionó que el perro tenía una clase de...
Yes.
39-year dog. Maybe they're just counting dog years. I don't know. Maiko is well over 39, and we make him wear a collar because he bites himself.
Yes, she can say yes or no. It's asking for an affirmation of that. Also, we've heard testimony about it already.
El perro tenía una clase de collar puesto porque tenía la tendencia de rascarse o de morderse, algo así.
Sí.
Yes.
Now, back in June of 1994,
Ahora, en junio de 1994,
did you have a friend by the name of Sylvia?
¿usted tenía una amiga con el nombre de Silvia?
Sí, señor.
Yes, sir.
And at that time, do you know Sylvia's last name?
¿Y en ese entonces usted sabía el apellido de Silvia?
No.
No.
Did you see Sylvia in court here, I guess, on Tuesday afternoon?
¿Usted vio a Silvia en esa sala del tribunal aquí, supongo que el martes por la tarde?
Sí.
Yes.
And is that the same Sylvia that you knew back in June of 1994?
¿Y esa es la misma Silvia que usted conocía en junio de 1994?
Sí, señor.
Yes, sir.
Was Sylvia a friend of yours in June of 1994?
Silvia era amiga suya en junio de 1994?
Sí, señor.
Yes, sir.
Excuse me, but I thought Mr. Cochran was not allowed to go into this.
I thought the court had indicated. May we approach?
Yes, please, with the court.
Hey, we haven't had a jury in here for so long that we haven't had a sidebar in forever. Why is he over there? Get on your own side.
All right, thank you, counsel. Mr. Cochran, you may continue.
Thank you, very kind of you. Now, Ms. Lopez, have you been promised anything at all of a monetary nature for your testimony here?
Ahora, señora López, ¿se le ha prometido a usted alguna clase de compensación financiera a cambio de su testimonio aquí hoy?
No, señor.
No, sir.
Have you received anything from any person for your testimony here and on last Tuesday?
¿En algún momento dado ha recibido usted alguna clase de compensación por su testimonio que ha dado aquí hoy y el jueves?
No, señor.
No, sir.
Have you received, however, some funds in the mail and through Western Union from other people throughout the United States since you testified last Friday?
Overruled.
¿Pero ha recibido usted fondos de otras personas de los Estados Unidos a través de Western Union?
Sí, señor.
Yes, sir.
Have you also received some funds and some help from your lawyer, Mr. Jones and Ms. Hamburger?
¿También ha recibido usted fondos de su
Have you also
abogado?
received some funds
y de
and
la
some help from your
de-
lawyer,
I'm
Mr.
sorry,
Jones and Ms.
Mr. Cochran, could you
Hamburger?
repeat that question?
From
¿También ha recibido
Mr.
usted
Carl
fondos
Jones and Ms.
de-
Maya Hamburger.
del señor Carl Jones y de la señorita Maya Hamburger?
Me han comprado mi ropa.
She has purchased my clothes.
What does that mean? If you make a mistake, you can't make a mistake. It's a wedding. It's a wedding. People are going to laugh. People are going to cry. People are going to fight. People are going to joke. People are going to sit in the corner wishing no one would talk to them. People are going to walk around and talk to everybody because they haven't seen them in forever. Just go and drink and eat in that order. Drink and then eat. You're going to have a great
Received
time.
anything else other than that?
¿Ha recibido alguna otra cosa aparte de eso?
Flores.
Flowers.
And who'd you get the flowers from?
¿Y quién le mandó las flores?
Muchas personas, no recuerdo ahorita.
Many people, I don't remember right now.
They were not from your lawyers. Is that right?
No fueron de sus abogados, ¿es eso
No.
correcto? No.
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 Very well, I have nothing further at this point, Your Honor. Thank you.
Thank you, Mr.
Gracias,
Cochran.
señor.
Thank you, sir.
All right, Mr. Darden.
Buenos días, señora López.
Buenos
Good
días,
morning, sir.
You understand that today, just
Almost.
as you were last Friday,
Rosa Lopez is the maid or the housekeeper of the next door neighbor, not of Mr. Simpson.
you were
I
under
thought he
oath.
was too.
¿Entiende usted que
Overruled. Proceed.
hoy, tal como lo fue el viernes pasado, usted está bajo juramento?
Sí.
Yes.
Okay, and you understand that oath, right?
Y usted entiende ese juramento, ¿correcto?
Overruled.
Sí.
Yes.
And you understood it last Friday when you testified?
¿Y lo entendió el viernes pasado cuando dio testimonio?
He
Sí.
lies.
Yes.
And you understood that oath on Monday when you testified?
¿Y entendió eso también el lunes cuando dio testimonio?
Sí.
Yes.
Okay. All right. That's a good breaking point. We did good. Do you guys, this is not until OJ is over. Okay. So, do you guys want to see a taste of what I'm doing next? Do you guys want to see the trailer of what I'm going to do after the OJ case is over?
The Trial of Lizzie Borden.
In a quiet town in 1982, a father and stepmother were murdered in broad daylight.
Dress burned, a note that never existed,
A killer who knew the house too well.
Lizzie Borden took an axe and gave her mother 40 whacks. When she saw what she had done, she gave her father 41.
I realized there were 2 M's in that last sticker I got. I'll fix it. All those voices were me. I did them all with this voiceover thing. Doesn't that look interesting? Oh my God, I can't wait. I can't wait. I'm not going to get mad this time like OJ's making me. I'm not doing the entire trial word for word. Nope. Going to do 5 or 6 hours. Just going to dramatic parts and all the opening statements and all the closing statements, but just the dramatic parts of the trial. It's not going to go on for a year, although the trial was only 14 days. So my best guesstimate, if I did the entire thing verbatim, it would only be like 24 hours long. It's like 24 days. We could wrap that up in half a month. But that's what we're doing after OJ. All righty, guys. Thank you so much for coming out today. I really, really, really appreciate it. Happy Easter. I hope your wedding. I hope your son's wedding goes perfectly. And if it doesn't, it's fine. Trust me. Problems that happen at a wedding are what you talk about for the rest of your life. Oh my God, remember at the wedding when da 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 did that and da 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 did that, and I said that she was a da 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 da, and the microphone heard me. It's fine. It's perfect. Problems at the wedding make the wedding better than everything going perfect. And don't forget to dance. I mean, you're going to dance with your son, of course, but don't forget to dance and eat. Actually, make sure that the bride eats. Just follow her around and shove food in her face, because brides never eat at their wedding and they're always freaking hungry. Bye, guys. See you soon.